It's nice to be back at Seyfarth Shaw. And I wanted to ask, is there anyone here from the EEOC Chicago District Office? Anyone in the room? There might be some people might be listening. This trip also afforded me a chance to visit with the Chicago District Office yesterday, which I was really happy to do. Well, I want to thank Jerry for asking me to participate in this event. He actually asked me to participate in this before I was named acting chair. But I also want to publicly thank President Trump for appointing me as the acting chair and entrusting me with the responsibility of the EEOC. And I also want to thank Jenny Yang, who is now Commissioner Yang and our immediate past chair of the EEOC for the transition that we've had at the Commission. We are a very collegial group at the EEOC. We are now 4 commissioners. Commissioner Connie Barker was not reconfirmed for her position at the end of the Senate term in December. So I am 1 Republican, 3 Democrat commissioners, Jenny Yang, my very good friend Hy Feldblum, and Commissioner Charlotte Burrows. But we have operated in a bipartisan fashion in the time that I've been at the Commission, and I fully expect and hope that we will continue to do so. I did want to say just a couple of things, though, at the outset, which is that, it's a new administration, but the EEOC remains committed to its core values and its core mission, and that is not going to change. We are an enforcement agency, and we enforce some of the most important civil rights laws in the country. Having said that, it is a new administration, and President Trump has made it very clear that he is interested in jobs, jobs, jobs. And for many years in my time at the Commission, I have been saying that we are the Equal Employment Opportunity Commission. Underscore employment opportunity. And I think it is incumbent upon us at the EEOC in terms of our approach, particularly on policy, to make sure that we are doing things in a way where we recognize the dynamic workforce that we all of you certainly live with, and where we recognize the kind of business practices that are necessary for companies to be competitive today, and that those thoughts and notions get incorporated into our policymaking. So the President has also made it clear that in terms of regulatory policy in particular, and we play a big role in that, that where there are opportunities to refocus things in a way that will foster economic growth and foster job growth, that is something that we should be mindful of, and we are not exempt from that at the EEOC. I do think that it is certainly the case that, again, I don't think it has to be the case, I should say, that we have to, in our approach to policy, be at odds with the employer community in everything. I have spent many years working on lots of regulations and lots of policies, and oftentimes the approach is to try to write the complete contingent claims contract, which we all know there is no such thing as the complete contingent claims contract, and trying to do that in regulatory policy often doesn't work. So again, I am certainly committed and always have been to the mission of the agency, but I think that our approach, it is a new day, and to the extent and where we can be able to help foster employment opportunity and economic growth, that is something that we will be focused on. Again, we are the Equal Employment Opportunity Commission, underscore employment opportunity. And that is something that I think we need to have a focus on. With that, let me turn to some slides, and I will try to go through these quickly. Oh, there we go. So as I mentioned, we are now a 4-member commission. So the Commissioner Yang, I want to call Jenny Chair Yang, is still at the commission. Her term will expire July 1st of this year. And so President Trump will nominate 2 new Republican members of the commission. There's a seat open now that had been the seat that Commissioner Barker held, and then Commissioner Yang's term will expire in July, and our general counsel's position is open. Most of you here are familiar. David Lopez, who had been the general counsel during the Obama administration, had actually announced his resignation before the end of the Obama administration, and David left the agency in December. Under the Federal Vacancies Act, by operation of law, the career deputy general counsel becomes the acting general counsel. So we currently have an acting general counsel, Jim Lee, who's been with the agency for many years and very experienced, but he's in charge of the general counsel's office right now. So it will take some time. The EEOC is one of many boards and commissions across the government where the administration will be filling out positions. So it will take some time, I think, until those positions are filled. And the ones that I'm mentioning, the 2 commissioners' positions and the general counsel position, are all presidential appointments, Senate confirmed. And that process in and of itself takes some time. So, but the work of the EEOC goes on, and as I mentioned, we are a very collegial group at the commission, and I've worked in a bipartisan fashion for many years with my colleagues on the commission. In particular, my colleague Commissioner Feldblum. Although I always like to kid her that she thinks that bipartisan means that I agree with everything she has to say. And if I don't, then it's partisan. So just let me give you some basics in terms of things that we dealt with over the last year. So, and this is all from the most recent fiscal year, 2016. We had 91,000 charges filed in the last year. I think some of you have been aware of this over the past couple of years, that retaliation is now the single highest category that we see in terms of charges. Race constituted 35% of our charges, and disability another 30%. We at the same time, those are incoming charges. We resolved another 97,000 charges during the year. 15,000 of those had merit resolution. So that can be everything from a mediation to something that gets resolved at a conciliation stage. We had 3,100 reasonable cause findings, 1,300 successful conciliations, 1,700 unsuccessful conciliations, and this is all the monetary relief, $348 million. That is before litigation. So in terms of what the agency recovered. Just to give you, I wanted to, for my own purposes, get some more historical perspective. So if I actually went back to fiscal year 2002, and this will give you some idea of what the charge filings have been like. When I came on board on the commission in 2002, there had been a pretty significant increase, and we were receiving close to 100,000 charges per year. So that's been down a little bit, and there has been a big effort at the commission to reduce the backlog, and that is something that is still a priority. Congress cares a great deal about it, and everyone at the commission cares a great deal about it in all of our field offices across the country. Our conciliation rate, and Jerry and I were talking about this a little bit earlier, and I'd be interested later when we have time for discussion. The conciliation rate, has been the raw number of successful conciliations has been relatively stable over the past few years, but we have had a higher rate of unsuccessful, or a higher rate of conciliations that have not been unsuccessful, which is a lot of double negatives. But the point being that there seems to be an increase in willingness to conciliate, and I'm very curious and would be interested in people's thoughts on what is driving that. I've been very interested for the past 2 years on what might be driving more successful conciliations. I don't know. I'm very curious if it's insurance coverage related. I don't know what the factors are. Costs of litigation. I'm in a room of lawyers, so you can all educate me about that. In terms of the lawsuits that we've filed, though, this has been declining, and you'll see. So last year we filed in federal district court 86 merit suits. 18 of those were systemic. 55 were individual suits, 13 non-systemic class, and then in addition to that, our district offices resolved another 139 merit suits. So that was an additional $52 million in monetary recovery. The next slide, this is what I wanted to show you in particular. So this is a comparison of the number of suits that were filed during the Bush administration and the number of suits that were filed in the Obama administration. And I'm not doing this, I'm not showing you this for some, to make a political point, but I want you to look at the raw numbers of how, the red, of course, is the Bush administration, and the blue is the Obama administration. But if you look at, so the beginning of the Bush administration, fiscal year 2002, there were almost 350 lawsuits filed. The first year of the Obama administration, 250. And we went from 250 down to 86 lawsuits last year. But at one point, a decade ago, there were over 400 lawsuits being filed by the EEOC nationwide. And now it is true that we have had an emphasis on systemic work. There was a systemic task force that had been put together in 2006, and much of that has driven, this will give you the sense of the declining number of suits in federal district court. And so when I've, been trying to ask about this, and a lot of times people will say, well, our systemic program, we have more systemic cases, but this gives you an idea of just over the last 6 years. So in yellow is the number of systemic cases we've had every year compared to the number of individual suits. I want to make a point about systemic, because this has occupied a lot of the Commission's work over the past few years. I am very committed to the systemic program. Every enforcement agency has to put its resources where it can have the most impact. And I am also, though, for the work that the EEOC does, am a big believer that the EEOC has to do a substantial amount of individual cases, because individual cases tell a story of discrimination. And they tell a story that can have an impact different from the number of people represented in a particular case, but it can have a broad impact in terms of public awareness. So I do think it's important for us to remain committed to systemic, but individual cases matter. I am not of the view that we should be all systemic all the time. I also think in terms of systemic cases that we probably need to, at a commission level, take a hard look at the amount of resources that we as an enforcement agency have to commit to systemic cases and how it is impacting our ability to do our work. We only have so many resources. And so it's important that we do cases, systemic cases, but I think we have to be strategic about them. So in the same way that, and Jerry has far more experience related to other class cases, but in the same way that I think you've seen a course correction by many in the plaintiff's bar over the past few years, certainly since the Dukes v. Walmart case, of being more targeted, perhaps more regional. I think that's something that we should probably take a look at. It seems to me that we can have an impact, if the purpose of systemic is to have a broad impact. We, the EEOC, can look at a policy or a practice, and if we are, let's say, bringing a case against a major nationwide employer, we can have an impact on that policy if we prosecute that case in a region perhaps as effectively as trying to do it nationwide. And that's something that I think I want, intend to, and I've had a chance to visit with the Chicago district office yesterday. I was in New York last week, but I do think that we need to do a hard assessment within the agency of how we are best using our resources, and if that means a bit of a course correction on the systemic program, I think that's something that's necessary. So let me mention the monetary benefits. As I mentioned, we've covered $52 million on that. Tell me how I'm doing on time. Okay. I'm just going to mention a couple policy things that we did over the last year, and then I'll mention one other thing and then turn it over to Jerry. So we've had a very busy agenda at the Commission on a number of policy things over the past year. We completed our rules on the wellness program under ADA and GINA. Some of this may be, and I don't know, but impacted by what will happen with the Affordable Care Act. Now, I will say that the wellness programs were the one area of the Affordable Care Act where there was bipartisan agreement when they passed the Affordable Care Act in Congress. So if Congress, makes some change on the Affordable Care Act, how that will impact wellness and then would have some spillover effect to our regs, I don't know. But our regs are there and in place. And I do fully recognize, for those of you from corporations, that you have a long lead time that you need in terms of knowing what the rules are you have to follow in terms of getting your wellness plan. So that is something that we're certainly cognizant of. We issued guidance on retaliation. Again, part of that was, we felt like we needed to update our guidance on retaliation because retaliation claims are so high. We revised the EEO1 to collect pay data. I'm sure people are going to ask me questions about that, so I will table that for now. We did enforcement guidance on national origin. We put out, and this is at a sort of a smaller level, a resource document about mental health conditions in the workplace. And for those interested in things that we do in the federal sector, we did regulations under Section 501 of the Rehab Act. Last thing I'm going to mention, two last things. One is I co-chaired a task force With Commissioner Feldblum, we issued our report in June on a task force on harassment in the workplace. And we had impaneled, and this was an 18-month effort, a group of outside experts, lawyers, but also academics, industrial psychologists, sociologists, to people who had actually studied harassment and over the past couple of decades. The idea being we were very interested in what can we do to prevent harassment. We see 30 years later, and we released our report 30 years after the Supreme Court case in the Meritor Savings Bank case. We see far too many charges of harassment, particularly sexual harassment, at the EEOC. And even though all of you are involved in this, there is a huge industry of compliance and training. This continues to be plague many of our workplaces. So we were interested in what sort of new approaches can there be in terms of preventing harassment. We started off with our task force members immediately saying, look, we all know what is legally actionable. What we're concerned about is trying to have some new approaches to prevention. And there were a number of recommendations that we made. Our report is available on the website. But those included, for all of you, looking at your training and perhaps modifying your training. We at the EEOC we consider the task force report really one step in, that was a first step in our process on this. We are internally looking at, are there other approaches to training that may be more effective? There were two things that we had recommended. One was workplace civility training, which is sort of a new kind of model in a lot of the training world. And the other is bystander intervention training. Now, we admitted we don't know if that works in a workplace. We were borrowing the concept from, if any of you have college students in your household, but the effort on college campuses about sexual assault on campus and looking at bystander intervention, and we are, offered the suggestion that maybe this is something that could be used in workplaces. There are no current training modules about it. We are actually having an internal meeting next week at the EEOC where we have invited in some experts and are going to explore this further. But the point being, the report that we issued was sort of one step, and issues related to harassment are things that I still care a great deal about. I'm not going to talk about, we made changes to the strategic enforcement plan over the past year, and I had actually voted against this. I had voted against it because it has been my firm view in the time that I've been at the Commission that the Commission, and by that I do mean the people appointed by the President and confirmed by the Senate, should have the opportunity to see and vote on more litigation that gets filed in federal district court, not less. The General Counsel, most of that authority is delegated to the General Counsel except under certain circumstances. And in this latest strategic enforcement plan, we ratcheted that back in a way that I did not think we should be doing. So I am a big believer in the Commission should speak first. We should not be advancing positions and arguments first in legal briefs. There should be some opportunity for the Commission to have been heard, and it is important for the governance of the Commission that the Commission put its by vote imprimatur on whether it's litigation that gets filed in federal district court and certainly in any policy matters, which we already do. I do not by any means think the Commission has to vote on every piece of litigation. I do believe we need to vote on more than we have done over the past 7 years. Later on, we'll talk a little bit about conciliations. I was going to mention, and Jerry has lots of experience with this, the mock mining case from a couple of years ago. which went up to the Supreme Court, and the Supreme Court, in a 9-0 decision against the EEOC had been arguing that we did not think that there was judicial review on conciliation, and certainly it has been a litigation strategy over the past certainly 6 or 7 years to really challenge the pre-suit processes of the EEOC, whether that's about conciliations or investigations. And so that issue of judicial review that went up to the Supreme Court, and while on its face the Commission lost in that decision 9-0, I actually think that decision was a victory for the EEOC because the language, the court did not adopt a good faith standard for conciliations and said that courts only needed to do, while they had the ability to do judicial review, they only need to do a bare bones review. I am committed to making sure that we have a good conciliation program, but which again, you saw, our rates of conciliation are more successful, but that all of the people at the EEOC who deal with conciliations, our investigators, all the people in our district offices, that they have good training, and that despite the language of the bare bones review of the mock mining decision, that we are fully prepared at conciliations, our staff, and that we make sure that we go beyond what you would think is required under mock mining. So I'll stop there.
Okay.